The government just gave American companies a way to hack foreign criminals on its behalf. In the same document, it told them the memo creates no rights anyone can enforce. Read those two sentences together and you have the whole story. On August 12th, the president signed a national security memorandum, not an executive order, called Expanding Capabilities to Combat Transnational Cyber-Enabled Crime. It sets up a program. The memo doesn't give it a name. It just calls it the program. Vetted American companies sign a contract and become participating companies. 2 co-executive directors, one designated by the Attorney General, one by the Secretary of Homeland Security, review every operations package and approve it in writing. What gets approved is 2 things: cyber surveillance operations, and I'm quoting, accessing information systems without authorization from the owner or operator with the intent to remain undetected, and cyber effects operations, manipulation, disruption, denial, degradation, or destruction. Here's a detail worth 2 seconds. The program runs out of the National Coordination Center. Go read the order that set that up, and you land on the Day 1 Immigration Enforcement Order, where the NCC is the command center for the Homeland Security Task Forces, co-led by ICE, Homeland Security Investigations, and the FBI. Offensive cyber against foreign criminals now runs out of an immigration enforcement structure. That's not a scandal, it's just a strange place to put it. And this isn't a bolt from the blue. This channel walked through the McCrary Institute's history of cyber offense, the argument that policy keeps trailing reality and that the fix is authority closer to the operator. In 2018, NSPM 13, which is still classified, reportedly pushed offensive cyber authority from the White House down to defense. In March this year, the administration's cyber strategy said it wanted the private sector doing more of this. Executive Order 14390 built the operational cell. This memo fills it. Every step moved the operator further from the president. This one moves it outside the government. Congress tried the blunt version of this twice. This channel walked through Senator Mike Lee's Cyber Letters-of-Marque and Reprisal Act and Tim Burchett's House version of it. And last August, Representative Schweikert introduced the Scam Farms Mark and Reprisal Act, actual letters of marque, the constitutional kind. Both were referred to committee, neither moved. Notice why that matters. Mark and reprisal is a congressional power, Article 1, Section 8. Congress wouldn't use it, so the executive branch built something it can do by itself, supervise contractors instead of privateers. And to be fair, the guardrails here are more serious than that bill would have been. Every operations package gets reviewed and approved in writing. Justice and Homeland Security can require a bond of at least $1 million forfeited if a company goes out of compliance. The 2 directors are barred from approving anything likely to kill someone or rise to the level of an armed attack. Accidental hits on American systems have to stop, get minimized, and get reported. Somebody thought about this. Hold on to that. One thing it does not do is ban targeting Americans. If an operation is directed at a U.S. person, the memo says it needs, quote, any necessary authorization, judicial or otherwise. Judicial or otherwise is doing a lot of work in that sentence. Now, the part that decides whether any company should sign. The memo does mention the Computer Fraud and Abuse Act. It cites Section 1030 once. And it borrows the CFAA's law enforcement exception almost word for word. Operations conducted, quote, exclusively on behalf of and under the supervision of the federal government. That's the theory. If you're inside the law enforcement exception, unauthorized access isn't your crime. It's government activity. Here's what the memo never says. Immunity, indemnification, safe harbor, liability. Not one of those words appears anywhere in it. And Section 5 says the memo creates no right or benefit enforceable at law by any party. No private company has ever tested that theory in court, and it does nothing about a foreign prosecution, a civil suit from a third party whose server got caught in the middle, or the conversation with your insurer. And as reported by the New York Times, a former senior intelligence official warned the approved companies could end up taking actions that exceed what the government's own agencies are allowed to do. That's not just one reading. As reported by the New York Times, a partner at Latham & Watkins who advises companies on geopolitical risk asked how a firm doing this under government direction manages the added risk to its business and its customers and how and when it discloses it. So what's on offer is a legal theory in a document that explicitly promises you nothing while you post the bond. That's not a shield, that's a hypothesis with your company's name on it. The history is worth knowing. In the 1820s, the United States appointed privateers at Caribbean pirates. They took bribes from the smugglers they were hired to stop and started hitting neutral merchant ships. In 1822, the Navy stood up the West Indies Squadron. That's what actually ended it. But there's a closer parallel than 1822. As reported by the New York Times, this moves the United States toward the way China and Russia already work, where the state leans on private hackers partly for deniability. One expert quoted there put it plainly, China copied the American education system to build its hacking talent. Now, the United States is copying China's system for deputizing private hackers. Two things to watch. Operating procedures are due in 60 days, around October 11th, and that document is where the attribution and deconfliction rules either exist or they don't. There's also a classified annex. As reported by the New York Times, it lays out how private operations get deconflicted with the government's own, which means the part that keeps those two from colliding is the part nobody outside can check. And the problem underneath all this is real. The White House says Americans reported losing $20.8 billion to cyber-enabled crime last year. Asking whether contractors are the right answer to that isn't a defense of the scam farms. It's asking whether the bond covers what happens next. Hey, thanks so much for watching. If you found this useful, go ahead and hit that like button and subscribe so you don't miss what's coming next. There's a lot more to dig into on this topic, and we're just getting started. I'm Veron. We'll see you in the next one.